done. I'm taking trains now.
They're just trying to help out.
No, it's not starting. Okay.
Open the Oldham County Code Enforcement Board hearing for today, June the 6th.
All right. Let's swear in staff. Raise your hand. Do you solemnly swear or affirm the testimony you're about to give this board is true and accurate to the best of your belief and knowledge, so help you God?
I do.
I do too.
Thank you.
Okay, I'd like to welcome Ron Forrest as our new board member. I hope everyone gets a chance to speak with him. And then we're going to go to the old business, the approval of minutes. Does everyone have a chance to approve minutes?
Make a motion to approve the minutes of April 4th, 2018.
Can you make sure your microphones are on, please?
I make a motion we approve the minutes of April 4th, 2018.
We have a motion. Do I have a second?
Second.
We have a second. All in favor say aye.
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 Opposed, nay. Okay, motion carries. All right, sir. Citation?
All right, good afternoon. The first case for today is citation number 501. That's at 2016 Montfort Circle, Crestwood, 40014. The owner of record is Gordon C. and Cheryl McCombs that reside at that address. A hearing was not requested. The violations were nuisance ordinance 89-800-846, sections 1 and 3. Section 1 is definitions, keeping or depositing on or scattering over the premises of any of the following: lumberjunk, trash, debris, abandoned, discarded, or unused objects or equipment, such as automobiles, furniture, stoves, refrigerators, freezers, cans, or containers. Section 3 is non-operating motor vehicles or machines to remain on the property longer than 15 days. And Oldham County zoning ordinance 280-100. No person shall keep any auto, truck, or trailer or boat unlicensed on the current year in any residentially zoned area unless the auto, truck, trailer, or boat is garaged. On January 19th, 2018, received a complaint on the condition of the property, conducted an inspection, found a moderate amount of dead fallen trees scattered throughout the property. Appeared to be at least 2 inoperable vehicles parked in the driveway. Turned out to be 3 total. A fair amount of junk, trash, and debris scattered around the driveway. Photographs were taken and a courtesy letter was sent to the owner of record. It's kind of hard to see in those pictures. The vehicles are behind the brush. I got some better pictures. There are the vehicles. On February 5th, the owner, Mr. McCombs, came to the code enforcement office stating he had some health issues. He went into detail about it, said he could not meet the compliance date, won't know if it could be extended. So I agreed to extend it to the 20th. And then on the 6th, I was in the area, so I did go by and take a look at it and observe some of the progress had been made up to that point. On February 12th, Mr. McCombs contacted me stating that some of the trees were being cut back by LG&E, getting them out of the power lines, and he was currently looking for a contractor to get some more of the trees out of the way. And he also said that he couldn't find the titles to the 3 vehicles that he had to have in order to get them donated, but he was in the process of doing that. So now, in between this time, we had the flooding go on too, so a lot of these cases kind of got put on hold, so it stretched out, but came back to March 12th and conducted a follow-up inspection and found that there was a tree trimming company on site, and I did agree to move the date to March 26th at that point. And then we go to April 12th, a follow-up inspection was conducted that found no further improvement had been made to the condition of the property. Took some more photographs, and a notice of violation was sent to Mr. McCombs. As you can see, the vehicles still remain there. A lot of the trash still remains. All the tree debris was still laying. LG&E contractors did cut the limbs out of the power wires, but that was pretty much the only thing that had gone on. On April 30th, a follow-up inspection was conducted that found a little bit more improvement in the condition of the property. However, the 3 vehicles still remained, and pretty much everything else was left untouched. Took some more photographs, and citation 501 was issued, sent via certified mail, return receipt requested, and a copy was posted on the front door of the residence. And that's what it looked like that day. I did a follow-up inspection this morning, found that only 1 vehicle remained on the property. All of the junk, trash, and debris around the driveway had been picked up and removed. A lot of the overgrown vegetation remained. However, some of it had been worked on. The owner was there and said that the last vehicle was due to be removed this weekend, and I reminded him that the hearing was today. So he understands that he doesn't have everything done, but he didn't feel like he needed to come in for the hearing. So that's the last remaining vehicle in the photo on the right. A bunch of the vegetation out around the road had been trimmed up. Further back, it's still fairly overgrown. So I think the evidence shows the violation. It's taken the owner quite a while to get anything done. And if he continues on, then I think he'll be all right. But he's got a ways to go. Any questions?
He's still in violation under all 3
Yes.
ordinances
Yes.
at this point? Okay. And you say it's still overgrown in the back. Is that the grass, the yard?
Grass, the bushes, just a lot of the undergrowth, shrubs. Pretty much all of his front windows are pretty much blocked by the shrubs. And when I talked to him this morning, he seemed that, he eventually wanted to get all that done, wanted to get his property into compliance, but he seems, it just takes a while.
Well, he mentioned he had ill health. Do you think if we gave him another 30 days?
I would like to think that 30 days would, but honestly, this case started January 19th, and we're already to June 6th. I don't know if 30 days would be enough time for him. I mean, he seems like a nice enough guy, but I don't know, in all actuality.
Any other questions from the board? Okay, are we ready to start with procedural matters?
Yeah, let's, can we have a little discussion?
Okay.
Just reviewing the facts, that the fellow does have some health issues, and albeit the progress has been made, but it is slow. I'm just vacillating between tabling till next month or going ahead and fining and giving him time for compliance. So, anybody else have any thoughts on that?
Any feedback?
Well, since it's been going on since January, let's go ahead and go through my opinion is, let's go ahead and go through the process maybe give him some incentive to finish in 30 days with a fine hanging over his head and see if that helps, and then we can look at it next month. I mean, that's my opinion.
Yeah, I was thinking either way, so that's fine with me. You want to do that or you want me to? Okay, procedural matters. The citation was properly issued on April 30th, 2018, to the owner, Gordon and Cheryl McCombs, and also the occupier. And notice of the hearing was given to the respondent. The respondent did not request a hearing to contest the citation within 7 days of issuance of the citation, but was notified of the hearing and is not present.
Okay, we have a motion on the floor for procedural matters by Steve Moss, seconded by Larry Chandler. Do I have a motion to move forward approved? Are we in favor?
Aye.
Opposed, nay? Okay.
Okay, nuisance ordinance violation, I move to find the violation of the Oldham County nuisance ordinance was committed because the condition or use of the premises are detrimental to the property of others, causes or tends to cause substantial diminution in the value of the other's property in the community. KOC 89, 800, 846-1. Storage of any of the following: junk, limbs, lumber, trash, debris, appliances, containers, furniture, and equipment. And condition or use of the premises renders the property dangerous, detrimental, or adverse to the health and welfare, or are offensive to the senses of the residents of the community. KOC 89, 800, 846-2. Property maintenance, overgrown property, lack of maintenance on the homes and structures. That concludes my motion.
Okay, we have a motion on the floor. Do I have a second?
Second.
All right, we have a second. All in favor say aye.
Aye.
Opposed, nay? Okay.
I move to find that a zoning ordinance violation was committed, and automobile, truck, trailer, or boat that is not licensed for the current year is being kept in a residentially zoned area in a violation of zoning ordinance 280-100.
We have a zoning ordinance violation on the floor by Board Member Moss. Do I have a second?
Second.
Okay, we have a second. All in favor say aye.
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 Motion carries.
And to the remedial order, I moved that the terms of the remedial order to bring the property into compliance within 30 days.
Okay.
On all three ordinances.
Okay, we have a motion on the floor that the property be brought into compliance by 30 days on all three ordinances by Board Member Moss. Do I have a second?
Second.
Okay, we have a second. All in favor say aye.
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 Opposed, nay. Motion carries.
And I moved to assess a civil fine, and April 30th was the date that, so I'm gonna do the math real quick here. It'd be 31 days in May, and what is today, the 6th? So we got 37 days at $75 a day. Is $2,775. And that fine be held in abeyance for 30 days, provided he meets the terms of the remedial order.
Okay, we have a fine for 37 days at $75 a day for the total fine of $2,775 to be held in abeyance if the property is brought into compliance. This is by Board Member Moss. Do I have a second?
Second.
Okay. All in favor say aye.
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 Opposed, nay. Motion carries.
All right, second case is citation number 502, and that's on 3713 Joyce Drive, Crestwood, 40014. The owner of record is Jerry Crawford. He lives at 518 South Main Street in Lawrenceburg, 40342. It's currently a rental property. Hearing was not requested. Violations include the Oldham County Nuisance Ordinance 89-800-846, Section 1. Keeping or depositing or scattering over the premises of any of the following: lumber, junk, trash, debris, abandoned, discarded, unused objects or equipment, such as automobiles, furniture, stoves, refrigerators, freezers, cans, or containers. And the Oldham County Address Identification Ordinance, 174-30-378, Section 1B, 5, letter A, the owner of each single-family dwelling structure shall place on the front of it the proper address numbers designated by the county in a conspicuous place in order that the address number can be seen and read from the street. On February 21st, Code Enforcement Office got a complaint on the condition of the property. I went out, conducted an inspection. Appeared to be 2 inoperable vehicles on the driveway in the side yard of the property. Quite a bit of junk, trash, debris piled on the front porch, on the ground next to the front porch, and on the side of the residence. Front gutter was partially pulled loose from the residence and hanging. And the street address numbers were not posted on the front. Photographs were taken and a courtesy letter was sent to the owner of record. There's photographs from that visit. On March 12th, a follow-up inspection was conducted. It found one of the vehicles had been repaired and moved, and the street address numbers had been posted on the front of the home. Mr. Crawford also contacted the Code Enforcement Office stating that he'd been out of town. Just became aware that there was a problem. They requested a 2-week extension so he could get his property brought into compliance. I agreed to extend the date to March 26th. On April 10th, a follow-up inspection was conducted. Found both of the original vehicles on the property were again inoperable. Also observed that the junk, trash, debris remained at the rear of the driveway. Photographs were taken, and a notice of violation was sent to the owner of record. On April 27th, a follow-up inspection was conducted. It found, other than the one vehicle being removed, no further progress had been made to the property. Photographs were again taken. Citation 502 was issued via certified mail, and a copy was posted on the front door of the residence. Conducted a follow-up inspection today. I found all the junk, trash, debris had been removed. The house numbers were posted conspicuously. The one vehicle that the current resident claimed was his daily driver was that vehicle parked in the driveway on the right-hand photograph that currently has a flat tire. So I don't know if that's his daily driver, if that's something that just happened today, or
But it is licensed.
it is licensed, yes.
Same vehicle you noticed on originally?
Yeah. He said that was his one vehicle. And we've gone through about 3 transmissions, I believe he said. And, but that was his daily driver. And he wasn't there today to ask, so I don't know what the condition is. That one technically it's inoperable. I don't know the circumstances behind it. Everything else has been taken care of, so.
In your visits, has that vehicle ever appeared to be in a different location?
Yes. Yes. It was actually gone on one visit, so
So it could be,
it could very well be. I found that the residents, they've appeared to be fairly honest with what they've told me, so. I think there's more than enough evidence showing that the violation, but like I said, everything appears to be in compliance with just the question about that one vehicle. I'd be willing to give them the benefit of the doubt on it, because they have come a long way.
would you recommend that we dismiss?
I feel comfortable requesting that y'all dismiss it.
So moved.
Okay, we have a motion on the floor that we dismissed. Do I have a second?
Second.
All in favor, say aye.
Aye.
Motion carried.
Will the owner get a letter indicating that it's been dismissed or what?
Yes, yeah, all the results from today, I'll generate final orders, letters of dismissal, whatever, and forward to the property owners, so. Okay, case number 3, be citation 503, for 9915 Constantine Circle in Prospect, 40059. The owner of record, I'm gonna try this, is Malenko and Alma Simic. I'm not quite for sure. They reside at that address. Hearing was not requested. Violations for this case, just the Oldham County Nuisance Ordinance 89-800-846, Section 1. I'll skip reading it word for word if that's all right. On March 19th, my office received a complaint on the condition of the property. Said it was overgrown. I went out, conducted an inspection, found it to be severely overgrown. Photographs were taken and sent to the owner of record. There's a lot of road frontage on this property. I'd have to post 20 pictures from each visit to get it all in there, so I've tried to highlight it. A lot of scrub brush. Looks like they've had a lot of trees and a lot of vegetation purposely planted, but just has been overtaken. On April 9th, a follow-up inspection was conducted that found very little, if any, improvement had been conducted. So photographs were taken and a notice of violation was sent to the owner of record. They did mow back from the fence a little bit in some of those areas. On April 26th, conducted another follow-up inspection that found no noticeable improvement on the condition of the property. Photographs were taken again, and citation 503 was issued via certified mail, and a copy was placed on the front door of the residence. Earlier today, conducted a follow-up inspection that found noticeable improvement had been made around the area of the residence, across the front, and immediately around the sides. The outer areas of the property, they haven't really done a whole lot with. That's down at the, stand on the road, the left end of the property. looking at it from the road. And with the shadows, it's hard to see. And that's down at the right end of the property. So I think there's evidence to show that, they were in violation, it was overgrown. They seem to be making progress on it, but it's been slow. I don't know, and I've not been able to get in touch with them. They haven't responded. I haven't been able to catch them when they're home, so I don't know what their plan is or.
Any board discussion? Board member questions?
You haven't had any conversation with them at all?
No, sir. No. No, and on the courtesy letter, I mean, I purposely put on there, please contact my office. And, my contact information is on all correspondence. I've been by the house, knocked on the door when I, actually served the citation, and not been able to get in touch with anybody.
In your opinion, if you had to guess, what percentage have they made in the progress of?
About 30%, I'd say. I don't know if it's.
Is this a large, acreage?
Yeah, it's pretty wide. I don't know exactly how big it is. I know it's a lot of road frontage. I don't know exactly how far back it goes. And like I said, they've made a lot of progress out there by the house. Not so much on down, the further away. But I don't know if, they have intentions of doing that, or if this is just a last minute deal before the hearing. I don't know.
This is in a subdivision that's everybody mows their yards. It's not out in a
Correct.
area where it's wild.
Correct.
I'm not familiar with this location.
It's I looked it up on Google Earth. It's a huge home and a huge lot and a couple of outbuildings. And it's at the end of a court, near the end of a court. So I just wonder if they know what they have to do, what they consider scrub and what we would consider.
Well, the work that they've done, a lot of what looks like bushes and trees that were specifically planted are still there, but the underbrush is gone. So they've got that part of it they've got. I just don't, like I said, I haven't been able to get in touch with them, so I have no clue.
Does it appear that they're living there?
Yes.
They're just not responding. Anybody else have any questions?
Being none.
Okay, I'll take off on this one. The citation was properly issued on, I move that the citation was properly issued on 5/1/18 to the property owner. And the respondent did not request a hearing to contest the citation within 7 days of the issuance of the citation, but was notified of the hearing and failed to appear. Therefore, the respondent is deemed to have waived the right to a hearing to contest the citation. Determination of a violation, determined that a violation was committed shall be final, and the board may proceed to the penalty phase.
Okay, we have procedure matters made by Board Member Moss. Do I have a second?
Second.
Okay, we have a second. All in favor, say aye. Okay, motion carries.
On the nuisance ordinance, I move to find that a nuisance ordinance was committed. KOC 8900 800 846-1. Condition or use of the premises renders the property dangerous, detrimental, or adverse to the health and welfare of residents in the community. KOC 8900 846-2, the property maintenance, overgrown property, lack of maintenance on the home, pools, and other structures. The violation was observed by the officer. I'm going to use the date of the citation of May 1st. So That would be 37, and substantial evidence that the record that the violation was permitted to exist for 37 days.
Okay, we have a motion that for a nuisance nuisance violation. Motion made by Board Member Moss. Do I have a second?
Second.
Okay, we have a second. All in favor say aye.
Aye.
Opposed, nay. Okay.
So I move that issue a remedial order with the terms as follows. Property be brought into compliance within 30 days. Today's date.
Okay, we have a motion on the floor that the property be brought into compliance 30 days as of today's date by Board Member Moss. Do I have a second?
Second.
Okay, we have a second. All in favor say aye.
Aye.
Motion carries.
And move to assess a civil fine of $75 per day. At the 37 days, which would be the same math, I think, as we used on the last one, $2,775. And that they fine be held in abeyance. To meet the terms of the remedial order.
Okay, we have a motion on the floor that the fine issued of $75 per day for a balance of $2,775 to be held in abeyance if the property is brought into compliance per the remedial order. Do I have a second?
Second.
Okay, we have a second. All in favor say aye.
Aye.
Motion carries. Okay, we'll just take a moment break.
Oh, did Darrell step out?
Yeah, he had to step out for a moment.
Allergies? What? Allergies?
Probably worse than that.
Talk and
Yeah, you want to?
I'll be his interpreter, how's that? And I have been sworn in, for the record.
Get my inhaler, I'll be right back.
Okay. The next case is citation number 504. It's for 4507 Timothy Way in Crestwood. The owners of record are Bill and Lucille Little, and it is care of Denise Little, P.O. Box 53 in Bedford, Kentucky, and a hearing was not requested. The violations are Oldham County Nuisance Ordinance Number 89-800-846, Section 1, keeping or scattering of premises, lumber, junk, trash or debris, abandoned or discarded objects or equipment. And also the violation of the address ordinance, KOC 1730-374, Section 1. It is a responsibility of the owner to display address numbers on the property. And just for your recollection, we have recently, I'll get that. We being the county have recently passed a revised address ordinance because emergency services aren't able to locate certain properties if they don't have addresses that are clearly visible from the street. So you're probably starting to see a few more of those. We have actually taken a proactive position over the winter and gone out and told people rather than finding them that they have to have their houses numbered, and that's working pretty well. On January 29th, 2018, the code enforcement officer received a complaint regarding the condition of the property. Mr. Townsend went out and did an inspection and found that several piles of junk, trash, and debris in the side yard and rear yards. Also observed that the street address was not visible and posted as according to the ordinance. And a courtesy letter was sent to the property owner of record. These are photographs that he took during that visit. On the left, you see debris in the yard that's visible through the fence. And also that there's, in the driveway, there's no posted numbers on the house. On February 21st, a follow-up inspection was conducted that found 3 vehicles, 2 parked in the driveway and 1 parked in the front of the home, all with no visible licenses. Also observed that there was a privacy fence gate that had been torn down and was laying in the driveway. Large amount of junk, trash, and debris along the side of the residence, throughout the side yard and piled in the rear yard. And also observed that the mailbox had been run over and was laying in the front yard. And the words "for sale" had been sprayed on the front of the residence, and he took photographs. So here's a picture, obviously, of the mailbox laying down, and you can see that in the right-hand photograph, the condition had gotten worse since his first visit in January. More photographs of the debris that were now visible because the privacy fence had been knocked over. On February 2nd, Ms. Denise Lytle, who again was the care of person, contacted the code enforcement officer stating the owner of the property had passed away and that she was the executor of the estate and that she was actively seeking an eviction notice of the current resident. Upon receiving the eviction order, she planned to clean up and repair the property. So Mr. Townsend did send a notice of violation on that date. However, he agreed to extend the compliance date until the eviction was granted by the courts. On April 10th, a follow-up inspection was conducted and found the street address numbers were placed on the front of the home and observed 2 unlicensed vehicles in the driveway, with 1 appearing to be inoperable. Still, junk, trash, and debris remained with no improvements. On April 11th, Mr. Townsend sent a letter to Ms. Lytle requesting an update regarding the status of the eviction plan and to bring the compliance in the property into compliance, and he did not receive a response. So these were pictures that he took in those April visits, and again, the conditions were pretty much the same as you can see. That although the vehicle had been moved, the privacy fence was still down and trash was seen. Can't really read what this is, but I guess this is the letter that he had sent. Got it, and he's nodding yes. On May 2nd, there was a follow-up inspection conducted that found no improvements had been made at the property, and it appeared as though no eviction had been received. Subsequently, he issued citation number 504 via certified mail with a return receipt, and also posted a copy of the citation on the front door of the residence. This is a picture of the citation on the front door as evidence that it was placed there. On June 6th, the follow-up inspection was conducted and found that very little progress had been made in bringing the property into compliance, and there remained a large amount of trash, junk, and debris in the driveway and in the rear, along with 1 remaining inoperable vehicle. This is the final picture
Yes, sir.
from
That was
today.
From today.
And is that it? So evidence presented shows a clear violation of the ordinances that were presented at the beginning of this presentation, with site visits on January 29th, February 21st, April 10th, May 2nd, and also on June 6th. Blank page. So with that, either I or Mr. Townsend will answer questions.
Any questions of the board?
Regarding the eviction,
Yes.
if I'm thinking back, you granted the lady an extension based on her verbal that she had filed an eviction, but there's no evidence of record of an eviction being
Right,
obtained.
correct, and I don't know exactly why. Apparently, she was the executor of the will. The original owners passed away. and she was one of the daughters. And she was the executor.
I'm right here, I'm Denise Liddell.
Oh.
I am the one of this,
Okay.
I'm Denise Liddell.
Okay.
I came because
Well,
there
let-
was.
let's,
Hold on, just a
let's,
moment.
Hang on,
I'm sorry.
just, if you want to answer these questions, then you can
All right.
just
Okay.
come up here and all we need is your name and address for the record. and-
Okay.
Get sworn in.
She needs to be sworn in.
Raise your right hand. Do you solemnly swear the testimony you're about to give this board is true and accurate to the best of your belief and knowledge, so help you God?
Yes, ma'am.
State your name and address for the record, please.
Denise Liddell, and my address is P.O. Box 53, Bedford, Kentucky, 4006.
Okay, you can tell us where we are today.
Okay, the situation is my mother passed away October the 1st, and my nephew is the one that's in the house. I have been trying to evict him. I was working with Ray Rowland, which was an attorney, and we had sent several notices to evict him. On March the 6th, we went to court in front of Judge Wheeler. She told me to go on and do the eviction. The eviction was filed March the 7th to have him evicted. Why they have not evicted him, he's still in the house today. I don't know why. I don't know why the eviction didn't go through, but apparently I received a letter on May the 1st that they have removed me from the executor and Mr. Combs have taken over the estate. Again, I have not been to the court to find out. I did not get no hearing, no reason why that I've been removed, so I don't know the situation there, but that is where we're at. That's why, I've tried. And I cannot get him out of the house, and every time I go down there, he physically tries to run me off the road and physically tries to attack me, so.
Question for you, Ms. Liddell.
Sir.
You said you filed for an eviction,
Yes.
but you had not had a court date yet.
I did not get a notification of the court date. Apparently, when I called the court court date was set for April the 30th or March the 30th. But anyway, I did not receive notification because they had the wrong address on file for me, which was told in court what my address was in February. So I never received the notice, so I did not make it to the eviction. But apparently they did have a hearing in court.
Mr. Rowland was present there? the
Mr.
attorney?
Rowland had withdrew from the case as well because of the situation, because Harold had made some threats and stuff to some other members, so.
Okay. So currently, this property is in probate.
Yes, yes, sir.
And ma'am, you mentioned that you were removed as executor of the estate
Yes, sir.
by letter?
Yes.
Do you have a copy of that letter?
I do at home, but I've been at work since 6 o'clock this morning, and I come straight here from work.
Okay, all right.
But I do have a copy of it.
Sticky, sticky.
Anything you want to guide us on? Any guidance you want to give us?
Well, I'm in a
You
position
need
where
to turn your mic on, please.
I have access to some of the court records, but they're not official court records, and I'm not permitted to put evidence into this record. If what Ms. Liddell says is true and she's been removed, then that basically takes her out of the code board case. And I think my advice would be to pass the case and serve Mr. Combs with notice and see if he's been appointed to be the public administrator, give him the opportunity to correct the mistakes, and then review it at another time, and potentially, I would hope that he could bring the property into compliance and get a recommendation for dismissal.
But we should have a copy of her letter for our record, removing her as the executor?
Right. I would recommend that Mr. Townsend find some documentation to substantiate what Ms. Liddell has testified to today before he does any service on Tate Combs.
Okay.
Do we need
Need a rec-
motion to
Motion.
instruct Darrell to do that? Go ahead.
I make a motion, we hold this case, hold it over till the next code enforcement meeting. at which time we'll examine the records of all parties and give Mr. Townsend an opportunity to contact the executor, or the current executor.
That'd be fine.
Concludes my motion.
Okay, we have a motion on the floor that the case be held until the next meeting so that Mr. Townsend can search to the executor of the estate. Do I have a second?
Second.
Okay, all in favor say aye.
Aye.
Motion is carried. Thank you.
Thank you, Ms. Liddell.
Thank you.
We have a couple more. Are you able to go ahead and move forward?
Yeah.
Okay, sir.
That was the last one.
Mm-hmm. Old business?
Yeah, the old business I wanted to bring up to the board. Both of our cases from the previous hearing have taken an odd turn. The first case was citation 499. That address was 6205 Osage Road. Excuse me, it's going to start again. And the final order was the property be brought into compliance within 30 days, which would have been May 4th, and with a fine of $14,400 being held in abeyance. Well, apparently on April 17th, the property was sold to Sean Mays, this gentleman right here. He contacted me right after he found out there was a code issue on the property, and obviously didn't want to be on the hook for the previous owner's fine. He bought the property, brought a dumpster in that day, several dumpsters actually, cleaned it all up. The property is now sitting in compliance, and he's in the process of gutting the interior of it also. So, being as how the property is now in new ownership and it's in compliance, and with his purpose of remodeling the house and moving his family into it, want to see if the board can consider doing away with the fine, because I don't want to hang the new owner.
I don't know how we do that, but was it brought into compliance within the time of the
Yeah.
remedial order?
Yes.
So
Time of the
that's pretty much meets the remedial order.
Was there a lien filed in the county
No.
clerk's office?
No.
I
No,
think
we-
he takes it free and clear then. if
Okay,
there's
I
no
just
notice.
want to make sure he didn't have any liability on it.
You need to dismiss it, yeah, I would think.
No.
Well,
No, I
it's
don't think so.
considered free and
If
clear.
it was brought into compliance during the time of the remedial order, then
Okay.
there's no issue.
He's
Okay.
clear.
The second one was citation number 500, and that was on 9205 Foxtail Court. And the final order on that was the property be brought into compliance within 30 days of the April 4th hearing, with a $1,500 or $1,575 fine to be held in abeyance. That property was bought on the courthouse steps on April 24th by a company called Pure Properties. I'm not that familiar with them. I've contacted them. They're in the process of redoing that house. They put a new roof on it. They're gutting the inside of it. I mean, it's as far in compliance, I guess, as it can get, considering it's being remodeled. And they have intentions of doing the house and selling it, putting it on
They
the
brought
market.
it in compliance with the violations that we cited?
Yeah, yeah. I mean, all that part's done. So, you know, but he was concerned about that order, because the order had already been issued.
Right.
And so I want to bring it back up, make sure, once again, that he wouldn't be
Pretty much same
Had the lien-
circumstances.
Had a lien been put on?
No,
Okay.
no.
If there's no lien filed in the county clerk's office, then a purchaser for value is gonna take free and clear. So liability might remain with the previous owner, but it won't flow to the new owner.
Okay. That's all I have.
All right. Being no further business of today?
I move we adjourn.
Good job.
Thank you, Daryl.
I'm sure that what it's gonna show is the take home is the administrator on that day. Call him and say he needs to evict her.
What do we do with these, Steve?
I usually just set them out there and they recycle and shred them.